Here we go.
Is the sound working? Can folks hear me?
Yes.
We can hear you.
Good morning, everyone. Sorry for the delay. I understand that Commissioner Sullivan was celebrating his birthday offline, and that's why we're a little bit late starting. But happy birthday, Commissioner Sullivan. I'm just teasing. I know you had trouble connecting to the WebEx, so no big deal. The commission will come to order now. It is Thursday, November 21st, 2024. This is an agenda meeting of the Minnesota Public Utilities Commission. I'm Katie Sieben. I'll take the role of the other commissioners who are present for the hearing today. Commissioner Tuma.
Here.
Commissioner Means.
Here.
And Commissioner Sullivan.
Here.
A quorum is present. We have 3 items on our agenda for today. Mr. Fournier, please introduce item number 1.
Good morning, Chair Sieben and Commissioners. Item number 1 is docket 24-253 involving all local exchange carriers in the matter of the telephone assistance plan review. Questions before the Commission are, should the Commission accept the telephone assistant plan fund review submitted on September 25th, 2024 for the 6-month period ending June 30, 2024? Should the Commission modify the TAP surcharge? Should the Commission modify the TAP credit? Before we start, though, I would like to introduce the new TAP administrator, Andrew Olson. He's to my left here. Andrew comes to the Commission as a result of the recent retirement of Teresa Staples, who served as the Commission's TAP administrator for the past approximately 12 years. Welcome to the Commission, Andrew.
Thank you, Mr. Fournier. And yes, thank you so much for that introduction and welcome very much. And we look forward to your work and appreciate that you're willing to work with us here at the PUC. On the docket itself, commissioners will start with questions first for the parties. And there are some parties that are online today and in the audience. Commissioner Tuma, do you have questions?
Madam Chair, just to the Mr. Christensen, if he's on.
Should be.
Mr. Christensen, there we go. Can you please state your name for the record? Welcome.
Morning, Madam Chair and Commissioners. For the record, my name is Brent Christensen. I'm President and CEO of the Minnesota Telecom Alliance.
So looking at the numbers and the decision to hold pat at this stage, give me a sense, I think, where you think the trend is. Is it accelerating the loss of lines such that we should be concerned, or because that seemed to be the question, are we losing lines faster than was expected before? And so kind of give me a sense of where things are happening in the marketplace.
Mr. Christensen.
Madam Chair, Commissioner Tuma, well, I think this is I don't know it's going faster than before. I think it's a steady glide path as technology evolves and we move away from traditional landlines. I know one of my members was talking about how they've had some of their copper lines stolen, and when they do, the customers they realize they didn't need that landline, and so they disconnect it. So I think between that and Lifeline that you get for cell phone service, I think it's pretty much been a steady increase for the last several years.
Nothing unusual. When I was reading the record, it seemed like we're holding pat a little bit on reducing the 3 to 1 cent just because we're concerned about the loss of lines is the way I read it. So I want to make sure that you guys are comfortable still with the 3 cents.
Mr. Christensen.
Madam Chair, Commissioner Tuma, yeah, I think that makes sense.
And Madam Chair, welcome Mr. Olson on board. This should be an easy one. I think it'll be a little more challenge as we look at the numbers going down the road, but I think it made sense to hold pat at this stage.
Commissioner Tuma moves decision option number 1 to maintain the current TAP credit level of $10 per line per month and surcharge of 3 cents per access line per month. Commissioners, is there any discussion on his motion? Then we'll vote on it. Commissioner Tuma?
Yes.
Commissioner Means?
Yes.
Commissioner Sullivan?
Yes.
I also vote yes. The motion passes 4-0. Thank you. Thank you to the parties as well. We'll move on to item number 2 when we're ready here. Good morning, Mr. Culbertson. When you're ready, please introduce item number 2.
Good morning, Chair Sieben and Commissioners. Item number 2 is docket number ET2/TL-23-410 involving Great River Energy in the matter of the application of Great River Energy for a route permit for the 115 kV pilot knob to Burnsville rebuild and upgrade project in Dakota County, Minnesota. The questions before the Commission are: should the Commission adopt the Administrative Law Judge's findings of fact, conclusions of law, and recommendation? Should the Commission find that the environmental assessment and the record created at the public hearings adequately address the issues identified in the scoping decision? And should the Commission issue a route permit identifying a specific route and permit conditions for the 115 kV pilot knob to Burnsville rebuild and upgrade project? Paper copies of the decision options are available in the back of the room. Staff and parties are available, and staff does not have any additional remarks. Thank you.
Mr. Culbertson, when you say paper copies of the decision options, those, we have the most up-to-date ones too, right?
Correct.
Okay, great. If the parties could come forward, I'd imagine there'll be a couple questions. And do we know if Art Kalmus is here? If he is, I don't think so, but. Do we have anyone online? Mary, do you know if that is named Art Kalmus or Kelms? Not sure. While we're waiting to figure that out, starting with GRE, could you please state your appearance for the record?
Good morning, Chair Sieben. Haley Waller-Pitts with Frederickson and Byron on behalf of Great River Energy, and with me is Mark Strophus with Great River Energy this morning.
Mr. Kirsch.
Good morning, Chair Sieben and Commissioners. Ray Kirsch with the Minnesota Department of Commerce, Energy Environmental Review and Analysis Unit.
Okay, Commissioners, who would like to start with questions? Commissioner Tuma?
Well, let's just get right into the Kelms questions. And I did go back and look closely at the assertion that this more consistently, his recommendation was more consistent with the wording of the EA. With tree height, I could not find that. So, I mean, I think the EA was quite clear on the purpose of tree height. The vegetation management plan seemed to me to deal with that tree height question quite well. I mean, but I just want to make sure we're clear on the record what that means. I actually went and did a little research, or staff did a little research on the law regarding trees. And so, as I understand the wording in your September 10th response, Ms. Waller-Pitts, and the kind of the way we deal with that tree height, the 45 going out from a particular point, but then there's also trees in the right-of-way. So it's clear that anything that's in the right-of-way, you can go and you can chop down to the ground without any question. That's the way I saw it. There was kind of a definition of how that 45, it's a little bit different. So could you explain that so I understand it?
Ms. Waller-Pitts.
Sure. And I think I'm recalling correctly, Mr. Kalmus's, one of his questions at least was about the hazard tree outside the right-of-way.
We'll get to that. I just want to
Okay.
be very clear on how the 45 works and how you perceive it to work so that we're on the same page. I saw actually, displays in the EA and in the vegetation management discussion. So I just want to make sure we're tracking on how that works.
Chair Sieben, may I? So probably the easier way to explain that is we have a clear zone. That clear zone is typically 10 to 15 feet outside of the conductor. So when the conductor is not blowing, it's in its neutral position, the clear zone extends 10 to 15 feet. It depends on whether or not the trees are closer to the structure, because again, that provides that blowout zone. At the structure, the blowout is less than at the center of the span. So that's the clear zone. Beyond that, then it's kind of a 45-degree line coming up and allows for taller and taller trees as we go out.
And so someone could have shrubbery in the right-of-way that's in their backyard, that's sitting there, a low-lying, set of dogwood trees that never grow more than 10 feet to keep the snow out of their backyard. It could still be in your right-of-way, but you would have the right to go remove those at any time because they're in the right-of-way. Is that my understanding?
Yes, if we needed to get in there and move any type of landscaping for maintenance or repairs, we could take down any structures according to our easements and the existing route permit conditions. Now, with this particular project, it's a tight right-of-way. We understand people want maintenance or want vegetation in their yards, and the fact that we typically have road access to do our work, we're going to hopefully be able to be a lot more lenient on what we're doing with respect to vegetation clearing and taking. We're not interested in having angry landowners. Our vegetation people get out there, and we've gotten from some of the landowners very good comments about our tree contractor that we've had out there in the past. So,
And then here's where it gets a little the question mark, and that's where Ms. Holler-Pitts was going, was you get outside of the right-of-way. So you got your clear zone, which is a little narrower. You got the right-of-way. Then you got a tree that's sitting in somebody's yard that is within that 45 zone. You can trim that tree that's sitting off into that. That's part of what we're giving you the right to do. But the question comes, is that tree that may be dying, leaning, looking bad, that's sitting on somebody's yard, how do you deal with that? What's the process of, you're outside of your right-of-way, but you got the dead tree, that 100-year, cottonwood tree that now is rotting from the inside and it's bad. What happens with that landowner at that stage?
well, certainly, if it's truly a danger tree, and a danger tree is something that's dead or dying, we have the right to take that. We would, again, try to work cooperatively with the landowner and see what he wants to do. If they want us to cut half of that tree down on our side of the right-of-way, we would consider that. We would warn them that this tree is dying. By doing that, a strong wind out of the west is likely to blow it into your yard. This is not a practical decision, and we would have to work around that. We're good about helping them replace their vegetation. In fact, we have a number of landscape architects on kind of retainer for this particular project, that if people want to do some improvement, get rid of these trees that we've been scalping half, and that are not the most attractive way to go, or where we've been topping off trees, and get something in there that's a little more compatible with the right-of-way. So
walk me through the process then. What you see a tree, your staff goes down the line, they see a tree that's concerning. What are the steps that you take with the landowner from there when you notice that tree outside of the right-of-way that's a danger tree? What are the steps that you take?
We'd first let them know that we have concerns about a particular tree.
You give them notice, you contact them.
Absolutely. We don't come in and cut down trees without talking to landowners first. Every time we send folks out for maintenance, they are knocking on doors. There are letters going out to every landowner along the way, and that will consist in.
What if there's a dispute? What if the landowner says, I asked my cousin who's an arborist, and he says the tree is fine. What's the process then?
Well, at that point, I think we get to that kind of scenario which we just discussed. We believe this tree is at risk. It's at risk of falling down. If we cut the weight off our side, it's likely to fall into your yard. And I would imagine, I don't know that we've ever ran into this scenario, but I would imagine we would ask them to sign some piece of paper that says, okay, you've agreed that you want this remaining. We're going to trim it in accordance with our easements, but.
And they still say no. I mean, I would assume at some point with an easement, you have to come to agreement. The tree is on their property.
At that point, it would become somewhat of a legal issue. I'm not an expert on that. We would get Haley's partner at Frederickson and Byron to have conversations with them and tell them that, this is the easement. The easement says we can do this.
I looked at the cases there was a couple cases that talked about there was mediation done, mediation failed. At that time, the utility actually took the trees down, and the landowners sued them for treble damages, which is in the statute. And so there is, I would assume, Ms. Haler-Pitts, a motivation on the part of the utility to avoid having that conflict, given the fact that there are treble damages. They're going to want to work this out before they cut that tree down.
Chair Sieben, Commissioner Tumas, certainly that's the case, and I think we also explained in our written comments in response to Mr. Calms that that the easements that the company typically acquires covers hazard trees outside the right-of-way as well.
Yeah, and I assume it would. I suppose you get in a situation we go down a whole bunch of hypotheticals. Well, what if the tree's not on the easement giver's property? It's the neighbor's property. There is at some point at least a obligation, I would think, that you have to work out some mediation or work with something before you get caught into a situation where you have the possibility of being sued for treble damages.
Chair Sieben, Commissioner Tuma, yes, I think there's certainly, as Mr. Strofus described, there's a process that the company would use to work with landowners to try to resolve that short of court action.
And that to me is critical as I look at the suggested changes. There are steps, processes that go by. It's not just you coming out there strong-arming somebody and cutting their tree down. There are things that we're doing, and there's a reason why we're doing it. I mean, you look at the blackout that hit the East Coast in, I think it was 2003. It was a line in Ohio that dipped too far when it was being overused, and it got down to less than 15 feet, hit a tree, arced, and all of a sudden we have riots in New York. That's not what we want. I mean, we've started solving some of those problems by having RTOs, but that's the point. There's a reason why we want to have a clear zone under these, and I think that's where maybe the last part of Mr. Kelm's suggested changes to the language of 5.3.10 probably a little too far and where we don't want to go, and I totally agree with you, but I wanted to make sure there is conversations with landowners. We're not just coming out there and cutting trees down willy-nilly. So now, but I look at Mr. Kelm's suggestions, and I actually find the first two ones reasonable. That's where he suggests that in addition to kind of looking for ways to maximize the extent of practical wind breaks, shelters, living fences, and vegetation as it relates, and it says trails and streams, and he suggests residents, and we're going through a very residential area here. I don't know why residents wouldn't be elevated to the same place of a trail and a stream in this situation. Do you have any objections to that language being added? It seems to be, to me, just a reasonable consideration that you need to not just look at trails and streams, but homeowners who put up windbreaks and have vegetation there. Any concern with just adding that in there?
Chair Sieben, Commissioner Tuma, if we may just.
Sure.
Commissioner Tuma, tell me one more time what you were suggesting?
So under on page 5 of the briefing papers, 5.3.1, Mr. Kell made several suggestions. We just talked about the tree
Yeah.
height. But he made 2 suggestions. One, the private residence being considered at the same level as a trail and a stream for, windbreaks and why they're there. I mean, it seems to be a reasonable request to put residents in there. And then the other one was human and environmental impacts was the second. But why it's important, they need to be that in mind. That seemed to be reasonable to me too. And so that's what I was asking if we were to make some adjustments. I don't think after that we make any changes, but those 2 changes seem to be a fair reflection of what we're trying to accomplish here.
Chair Stephen, Commissioner Tuma, I think those additions are acceptable to the company with the context, right, of reliability and safety that you just discussed with respect to those standards.
We're going to lose that. That's critical. Mr. Kirsch, any concerns if we just add those first 2 suggested changes that Mr. Kelms had recommended?
Commissioner Tuma, no, I have no concerns.
Those really Madam Chair, the only questions I have, I think the project was well thought out, well planned, and the route is the route. I mean, that was given to us by the existing route, so there wasn't much work to do here. It would be necessary to do unless we were just going over 100 kV here. So I think it looks good, Madam Chair. Those are the questions I have.
Great. Any other questions for the parties from commissioners? Hearing none then, Commissioner Tuma, could you make a motion?
Sure, happy to. Madam Chair, I would move decision option 2, decision option 3, decision option 5, and then I would modify decision option 6 to read as follows, Mr. Whitty. It would be modify section 5.3.10 of the draft MPC permit, delete as, and then put these following words in, adding only the first 2 changes proposed in the, and then existing proposed would be there, proposed in the September 2nd, 2024 comments of Art Kelms addressing open quote, and private residence, close quote, and open quote, human or environmental, close quote.
Environmental impacts.
Impact, yeah.
Mr. Woody, do you have that?
No, but I can get it off the recording.
Good.
Okay, we
and
have
then
it.
number 8 also is the decision option number 8. So it would be 3, 5, 6 is modified, and 8.
And 2.
And 2. Sorry, yeah.
Is there any discussion of Commissioner Tuma's motion? Then we'll vote. Commissioner Tuma?
Yes.
Commissioner Means?
Yes.
Commissioner Sullivan?
Yes.
I also vote yes. The motion passes 4-0. Thank you very much, everyone.
Yeah, I got copies. A copy. Sure. I could do that.
Thank you. Jeff texted it to me. I can text it to him.
Did you get it? Yeah, that'd be great. That would be deeply appreciated.
Good morning, Mr. Nissen. When you're ready, please introduce item number 3 for us.
Good morning, Chair Sieben and Commissioners. Item number 3 is docket number E002/CI-24-248 in the matter of the Interconnection Ombudsperson Surcharge. The question before the Commission is what actions should the Commission take to establish procedures on funding provisions for the Interconnection Ombudsperson position? Staff filed a compiled list of decision options this morning, which includes Excel Alternative 5, Staff Revised 6, and Excel Additional 9 decision options. Commissioners have received a copy, and printed copies are available at the front of the room. Staff has one minor procedural modification to Decision Option 3 for Commissioners to consider, and I'm happy to explain that at any time. I have no further remarks, but I'm available for questions. Thank you.
Thank you, Mr. Nissen. Let's just first hear your explanation of decision option 3.
Great.
And just making sure, Commissioner Means and Sullivan, do you both have the revised language that Mr. Nissen is talking about?
It's the one that is in Granicus right now, right? Posted to Granicus? Because I'm looking at that.
It's the list of compiled decision options that was filed this morning in the docket. And email.
Oh, okay.
We'll have someone email or chat it to you too, Commissioner Sullivan.
I think he said he got it. But
Oh, you got it?
Yeah.
Great.
Okay.
So decision option 3 is a proposal to modify the MNDIP. If you look under section 1.1.4 in that decision option, staff.
1.5.1.
I'm sorry, yes, 1.5.1.4. The red underlined additional language. Staff recommends deleting in docket 24-248 at the end of that language. This would allow staff flexibility to make annual changes to the surcharge in an annually recurring docket or other docket. And so that would allow that flexibility in MNDIP by striking that docket reference there.
And Mr. Nissen, that red underlined language that's also in decision option 3, is the
correct? The red
language
underline was
offered
in the
by-
original proposed decision option from Mencia.
So all of 3, including
Yep.
the new language in red, is from Mencia, and the department agrees with that too.
That's my understanding from the record, yes.
Okay, great. And we'll have the parties come forward and then hear from the parties on their preferred decision options. I think that might be helpful at this point. So why don't we start with appearances, and I know we have folks online too. So starting with Mr. Denniston.
Good morning, Chair. Jim Denniston on behalf of Excel Energy.
Good morning, Chair Sieben. David Moberg on behalf of Mencia.
Okay, and then it looks like Ottertail is online.
Yes. Very good morning, everybody. My name is Cody Anderson. I'm with Ottertail Power Company.
Welcome. And for Minnesota Power?
There's Jennifer Kuklinski with Minnesota Power.
you're a little quiet there, Ms. Kukulski.
Ms. Kuklinski, could you say that again? You were we could barely hear you.
Chair Stephen, can you hear me now?
Kind of. Sorry, it's our lovely WebEx, I think. Try one more time, please.
Chair Stephen, I'll talk louder. This is Jennifer Kuklinski with Minnesota Power.
You got you that time.
Now you woke us up. Thank you. And David?
Hi, good morning, Commissioners. David Muller on behalf of Minnesota Power.
And good morning. And for the department, please.
Yeah, good morning, Chair Stephen and Commissioners. This is Justin Taylor financial analyst with the department, and I have with me my supervisor, Nancy Campbell, with the department.
Okay, great. Thank you. So we have a good record here, but there were some changes late. So why don't we just do another round of your preferred decision options or any comments you'd like to make about the new decision options that were filed, and we'll start with Mr. Dennison.
Thank you, Chair. Although we have proposed decision options 1 and 2, we see that staff recommends going a different direction, and we're generally fine with that. So we can support number 3 as edited this morning by staff for A through D. Our alternative 5, we'd recommend as opposed to the regular 5. We can support 6, 7, 8. We also recommend the Excel additional 9. And I can go into number 5 and 9 at some point if you like.
Revised 6 or 6?
The revised 6, sorry, yes. That's fine.
Okay, thank you. And how about Otter Tail next? Mr. Anderson?
Sure. So for Otter Tail, we will go with option 3, 4, A through D, 5 revised, number 6 revised, and then 7, 8, and XL's number 9 as well.
Okay, thank you. And Minnesota Power?
Chair Sieben, Minnesota Power supports decision options 1, 2, or 3 if that's the direction the Commission wants to go. Minnesota Power also supports decision options 4A through D, decision option 5, and staff revised 6. Minnesota Power is not opposed to decision options 7, 8, or 9.
Revised or alternative 5 or 5?
Alternative 5.
Okay, and Mr. Moberg, please.
Chair Sieben, Mencia would support decision option 3, including the revision by staff, 4, A through D, as well as E, which I can get into if you would like, 5, 6, 7, and 8, and...
Wait, just 1 second. 5, but not alternative 5? Just regular 5?
Yes.
Okay. 6?
6, 7, and 8, and we would not support XL 9.
Okay, and thank you. And for the department, please.
Thank you, Chair Sieben. We would be supportive of the revised number 3, number 4, A through D.
Just a second.
Excel's alternative for 5. The Commission staff revised 6, 7, 8, and the proposed additional from Excel 9.
Okay, thank you. Who would like to begin with questions for the parties about this? Commissioner Sullivan?
Sure, I would. I guess my question for Mr. Moberg is regarding Excel's decision option 9. What was the nature of your objection to that or opposition to that?
Chair Sieben, Commissioner Sullivan, we would agree with the comments by PUC staff in the briefing papers that the AAA standards described in decision option 9, they're a detailed and comprehensive process for matters outside the scope of the Ombudsperson's role and perhaps do not provide the flexibility necessary to fulfill the obligations of the Ombudsperson. The current CAO process, we believe, is adequate, but can be changed in the future if such a change appears warranted. And I would just like to clarify something, Commissioners, to what I said earlier. Mencia would support alternative 5.
Alternative.
Beat me to the punch because I was going to ask you about alternative 5. I was looking at it and I was like, okay. So thank you for making that clarification.
Thank you, Commissioner.
At this time, I'm working on something else in my brain, but I can hand it back to Commissioner, to other folks for questions.
Along that line, Madam Chair.
Commissioner Tuma.
To the company on number 9.
Which company?
Well, Excel, because they proposed it. I should say the proposer as opposed to the company. I'm looking at the statute, and I'm trying to understand from the statutory expectations of the legislature for creating this, and I don't see that they intended it to give it the constraints that seem to be created by 9. So it just 9 just doesn't seem workable. So give me what you're thinking and the reasoning behind it. It just doesn't seem to be a very workable option.
And Mr. Dennison, if you could add to that too, like why you think why that language is proposed too, just in a more general sense.
Thank you, Chair and Commissioner Tuma. Let me first talk about why and then talk about the statute. So the Ombudsperson has several roles. One of the roles is to facilitate resolution of disputes, which we view as being taken on the role of a mediator. That is only part of their duties. But when they act in the role of a mediator, we believe it's important that they should adhere to national standards based upon what the mediator should do. So let me give you a hypothetical, made-up example as to this type of situation we're trying to avoid. Let's assume we're in a dispute with another developer, and it goes to the Ombudsperson for mediation. So part of the standard form of mediation is the mediator meets privately with each party. And the normal expectation is that things that are said to the exchange communications with the mediator are confidential, and there's a lot of learned practice behind that. But let's say that in that private discussion with the mediator, the other developer, in good faith, makes a statement or a series of statements that end up being fundamentally false. The mediator then comes to us, doesn't share the information that was conveyed to them, and we are unable to resolve the dispute. A formal complaint's filed. It comes before the commission. Commission, talk to the mediator. What's going on here? And the mediator gives them the backstory with information we know nothing about. And perhaps it angers the commission. In a hearing, we're faced with a wall of anger for something we have no idea what it's about. We don't think that's fair or just. And these rules here, but rules of the road on mediation that have been learned across the entire country based on many, many years of experience to be best practices for a mediator. So we want to get the rules of the road right before we start mediations. And we think that's just good practice. And it helps to preserve the integrity of the commission process.
Isn't that our staff, when they do this, they're not coming with this inside information. You get everything our staff knows from the briefing papers. So if there was a materially false statement made that is critical to the record, I would think our staff would put that into a briefing. I mean, that would be my expectation if it's not a trade secret provision. I mean, I would think that they would be obligated to do that. I would expect that Mr. Neeson would expect that from them. If it's a material piece of information, they provide it. They're not coming to us and giving us some secret side conversations. We're given a brief, and the brief is what everybody has, and that's the record. And so, if there's a wall of anger, it might be because we just don't like what you're doing. Okay? It's usually what we get here. I mean, it starts with these documents. They're not running into our office and telling us, "Oh, here's what happened at the ALJ hearing." Da 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 da. We really don't get this stuff until it actually is in a piece of briefing paper. So I'm trying to think. That scenario, just in my mind, should never happen. And Mr. Nissen, I would think that's your expectation, that if there's some material facts, you expect our people to put it in the briefing paper, right?
I think, Commissioner Tuma, we don't need to ask our staff a question on the record, but I think it's also, from my perspective and what I talked to staff about is, it's a little odd, Mr. Dennison, that this is coming up in a late filed decision option. I understand that the statute's new and we're working out the process here, but, there are other provisions of law that govern the Data Practices Act and how customer utility data is defined as private data on individuals. And so maybe this just, my perspective is, you have a good argument here right now about why we should, start with the American Arbitration Association standards, but I'm just not sure we're quite at the time now where we should adopt that without having like a further discussion too, and more analysis on.
I guess I could have read it in the record, but it's not. I don't have it in the record what this is, and so I'd hate to be putting constraints on our two wills as they work with our staff and Mrs. Tome to restrict them on what they say and how they want this position to be structured and how it works. They may have some plans on how the mediation should look, but I don't want to, at this stage, with what I have in the record, to be restricting them. I mean, you get my concern there. I mean, I'm a little nervous to apply, me being the manager here. That's what we pay these guys for. So, and there's two propositions here too in 9, and to the extent the commission expects or allows, the second sentence, communication between the ombudsman and commission staff, I don't understand what that proposition is trying to get at. What do you envision with that second sentence there? Is that they must disclose these conversations, or if they've had a conversation with internal staff about this, if the ombudsman come and seek advice from another staff member, they're supposed to disclose that? I don't know how this actually was intended to work, that second proposition.
Mr. Dennison.
Well, thank you, Chair and Commissioner Tuma. A couple of points. We raised this issue in our October 3 comments, and admittedly, the other parties didn't have a chance to respond, and we appreciate that. We appreciate the process of getting started. We appreciate that the mediator, the ombudsperson, might have their own vision as to what this should look like. But that's something that we have not heard about. Maybe it's in the works. Chair, you had suggested maybe more inquiry, more comments on this. Maybe that's the route to go. I don't want to abandon this. I think that what makes the mediations effective based upon the national standards are, you can tell the mediator certain things that you don't want to tell the other party, perhaps weaknesses in your case, perhaps strength in your case of a certain type that doesn't come out in the regular process. And to say there are no rules of confidentiality, that we're not going to define what's confidential, what's not. I think you've diminished the role of the mediator.
The second proposition is still.
Can I ask?
Go ahead. I'm still trying to understand what was trying to be gotten at. I don't even know how it even works. The second sentence works.
Sure. So I was thinking from the other direction, that the complaint, the dispute is not resolved, results in a formal complaint. And perhaps in developing briefing papers or getting ready for a hearing, there are, someone asked the ombudsperson, can you fill us in on what's going on here? And there may have been certain things said in confidence to the mediator. And I know you're saying that doesn't appear in the record. They should only stick to the record. But
that doesn't make any sense, Mr. Dennison. This is, I'm working backwards. Ombudsman, so mediation session involving the ombudsman is started, okay? Before that happens, okay, that person must make clear before a mediation session starts. So this is not at the end of it where there's a dispute. Before a mediation session starts, ombudsman, okay, needs to an extent the commission is expected, do what? I mean, tell them that we had a conversation about a mediation. I mean, I'm just reading this sentence and I just don't, maybe it's my dyslexic brain. I'm not seeing how this is supposed to work. I mean, it makes it sound like the mediator must disclose every conversation they had with me or with another staff member about a coming mediation session. That's what it looks like to me.
Yeah, no, I appreciate your comments, and I think if we flip the interpretation, in other words, before mediation starts, if there are no rules of confidentiality, let the parties know that before the mediation starts, because you cannot unring the bell. So that's the intent of the statute of its second sentence. Let us know the rules of the road before the mediation starts.
Okay, but that's not what I'm reading, and that's what causes me heartburn trying to adopt something and put shackles upon our ombudsman to do their job, because an ombudsman has multiple things, including mediation, to do here. The duties that are given to them are pretty broad, so it just seems to be possible shackles that I don't want to put on at this stage. Sorry, Commissioner Sullivan. I just hadn't got my brain around what the sentence said.
Commissioner
That's
Sullivan.
Okay. That's helpful, Commissioner Tuma. I mean, I guess I'm looking at this and I just think, we have the State's Data Practices Act and we have this new Ombudsperson statute, and it just feels to me like, that the way that the two work together is not conducive to the Ombudsperson getting, all the information that they would probably need to be effective. So you have a legislative problem, you have a statutory problem, and you're both vulnerable. Both MNCEA and the utilities are vulnerable to it. I mean, the Data Practices Act can be used by both to get at that information that's sensitive. So it feels to me like, Mr. Dennison, we can't do decision option 9. I mean, there's just our statutes are pretty clear. The National Arbitration Association, I mean, they don't carry any weight, compared to the statutes. So, I mean, I think you both have to go back to the legislature and get a fix if you want the Ombudsperson statute to work.
So, Commissioner Sullivan, you're pointing out that the mediated substance of a dispute could be subject to the Data Practices Act, regardless,
Correct.
because it wasn't
that's
specifically
what that's what I
excluded.
hear
And
is
so,
going on. Yeah.
And you're pointing out that especially the first sentence, like that wouldn't supersede the Data Practices Act of us telling our ombudsperson that he or she must adhere to the American Arbitration Association standards.
Exactly. They must adhere to the state's Data Practices Act and the new Ombudsperson statute. But
I think
there's a
this
conflict
is
there.
pointing out that, at least to me too, that 9 might not be enough or might not be sufficient to sort of handle this problem.
Not in the record we got. Yeah. Well, and Mr. Dennison, you have trade
Commissioner
secret protection. under the acts. I mean, if there's some sensitive data that you want to be kept trade secret, I would assume that you would just file a letter with the Ombudsman saying this is important trade secret information. We don't want this passed along because we don't want other developers to know we're making this offer to this developer. To me, that was what I thought you're trying to get at, is avoid having whatever offers you put to one developer be spread around to other developers just because you're trying to mediate multiple things at the same time that are in play, which I could get, but I would think you're protected by the Trade Secret Act in that situation. Wouldn't you be?
Can I just add, Commissioner Tuma, I want to augment that a little bit. They're protected by the Data Practices Act, the trade secret, but that's not going to protect them for all of the things that they want to share with the Ombudsperson that they may not want to share with the party across the table with them. Correct?
That's my understanding, yeah.
Yeah.
Mr. Dennison.
Thank you, Chair, and thank you for the dialogue and discussion, Commissioner Tuma and Commissioner Sullivan. There might well be some things we want to submit to the Ombudsperson that might not be protected under the Minnesota Data Practices Act. To your other point on whether or not adoption of the model standards would conflict with state law, model standards have a provision basically, saying state law will prevail in case of a conflict. So I think it's probably worthy of further comments by the parties. But you've raised excellent points to that. Thank you.
Yeah, I think I don't know if we just don't do 9 now, then Mr. Nissen, this topic do we need another comment period on this, or just wait and see? Maybe I should not listen to what I said to Commissioner Tuma and not ask you a question on the record, and we could take a break and.
Yeah, that's probably the way to do it. I apologize.
No, it's not. I'm doing it too. So a little TBD about decision option 9, or what would happen next in that regard, but it seems like we covered the other decision options. Are there other questions? Commissioner Tuma.
Just to understand, since we got you here, and my hope is that we do adopt the negative checkoff and we never see y'all back here again on this subject, so that we don't have to worry about it. So since we got you here, I just want to, and I kind of went around with staff on this and tried to understand it fully. And in the statute, the legislature sets a $50 surcharge. What I found interesting in what it didn't say up to or not to exceed, or it just said $50. And to the utilities, to their credit, started collecting that after the legislative session. So that has gone into place, and there's been some collections. But I just want from Mencia, did you view $50 as significant, or was that number just kind of picked out as that's the thing that gets us to the fiscal note that makes an FTE, and that we can go up, above, or below $50? Is that your understanding?
Mr. Moberg.
Chair Sieben, Commissioner Tuma, that is our understanding. Especially, we view the surcharge as flexible depending on the needs of the position and the sorts of issues that are crossing the Ombudsperson's desk, which is actually part of why we brought up what is now compiled under Decision Options 4E, for example. Because it's to provide the info necessary that appears necessary to determine which utilities and classes of customers are requiring the Ombudsperson's time, so that when the commission adjusts the surcharge, the commission could say reduce or eliminate it for customers not using the Ombudsperson's time, increase it for those who are. We understand this to be something that can be flexible as needed.
Well, that was my other question to the utilities. Do you see that? I mean, I guess I envision that we calculate it for all three of you, and no matter whether you're good, bad, or otherwise, If it's $46 in year, 2028, it's $46 to all of you. I hear something different from Mencia that, well, XL, you're good boys lately, so we're gonna only charge you $35, and Otter Tail, you've been difficult, we're gonna charge you $50. That's not what I envision, but do you think we have that kind of flexibility
Who's the question for?
for each of the utilities?
Mr. Dennison?
Thank you, Chair. Thank you, Commissioner Tuma. We read it consistent with you and not how Mencia reads it. The statute refers to initially the $50 on each application, and then to revise it, that's subdivision 3, paragraph C. They can only revise it as necessary to ensure that sufficient money is available to support the position, and the reserve in the account does not reach more than 10% of the amount necessary. Those are the two factors. There is nothing about revising it based upon per utility basis. I think the statute contemplates something that you were speaking about.
Ms. Kuklinski?
Chair Steven, Commissioners, Minnesota Power does not support decision option for E1 through 3. The company sees the same as Commissioner Tuma and XL Energy in a consistent fee across the utilities. The volume will, of course, be different, and decision option for E1 through 3 would be unduly burdensome for reporting with little customer benefit in Minnesota Power's view.
And Mr. Anderson?
Yeah, we at Otter Tail feel the exact same way both Minnesota Power and XL do. We would not be for. I think it's option 4, E1 through 3. We think that it should be equal among everybody as well. So.
And then
Commissioner Tuma.
the last question, I guess it's kind of, we have you here. I mean, we have one person hired who's our ombudsman, and she's in CEO doing the work now. So it says a new full-time equivalent, interconnection ombudsman, not plural, or even indication of plural. But it's funded with an FTE, so you go down to the definition of, what is to be funded as an FTE. And so I'm trying to envision at some point, we have the one person, that's the way it's designed, and I think that was kind of in everybody's mind at the legislature, how it was to work. But let's say we have a transition. Let's say we know that there's going to be a transition, and we want that ombudsman to be 75% ombudsman, and then we have assistant ombudsman who does 25% of their time in Mrs. Tome's office, and that flexibility is there to do that is what I'm trying to understand. Or was this intended that this is a position, only can be a position, and that's it? And so for Mencia first, it's not clear in the statute. It kind of seems that was what the intention, but I'm just trying to make sure that maybe there's some flexibility down the road where either you have that transition time, somebody's coming in that you want to start building up into this position, or even if you just want to divide the duties up and have two different ombudsmen so that you have 50-50, maybe two employees doing 50 of their time doing normal CEO stuff, but 50 doing ombudsman stuff. Is that flexibility in this statute? I wasn't there when it was drafted, but you guys were, so do you see that as a potential for future actions by our staff?
Chair Sieben, Commissioner Tuma, we agree with your interpretation. We believe that flexibility is there at the Commission's discretion going forward.
To each of the utilities, you guys were involved in this, so I just want to understand if you believe that flexibility exists.
Mr. Dennison.
Thank you, Chair. Yes, we believe that 75 plus 25 equals 100%, and that's, I think, the equivalent full-time position, yes.
You could even do two, like you said. Like I said, you could do 50-50, have two different employees?
Yes.
Ms. Kuklinski.
Chair Steven, Commissioners, Minnesota Power interprets subdivision 1A as one ombudsperson. Whether the commission interprets that as one full-time equivalent and divides the responsibilities, the company takes no position on.
And Mr. Anderson.
Thank you. Yes, I think that would be the exact same for us, is that we don't really have a strong opinion on that as long as it's split up, that 75-25 or 50-50, whatever it is, or 100% for just one person.
Commissioner Tuma.
That's all the questions I have, Madam Chair. That was very helpful.
Did you want to ask the department any? I missed them, I realized.
The department wants to weigh in. They seem to kind of be quiet here, but I would gladly hear their position.
Thank you, Chair Seaman and Commissioners. We concur as well with the one roll, or 50-50, or 75-25, however it makes most sense. And I think just overall, if we get a sample size, we'll get to kind of know how this is working over time. And just to get it started, I think we support what we mentioned before, but yeah.
Okay, thank you. If there are no other questions, we can move into deliberations. Commissioner Sullivan, do you want to make a motion?
Sure, happy to. So I will move, based on the conversation today, I'm most comfortable with the following. That would be decision options 3, 4, A, B, C, and D.
And sorry,
decision option.
just to be clear, you're obviously working off the compiled decision option sheet, so it has the new language in it.
Yeah,
Yeah, you are.
one that Mr. Nissen referred to, yep.
Okay, sorry to interrupt. So 3, 4, A
It
through
is
D.
dated November 20th, just to make sure.
Yep.
All right, okay, good. So, going back, so decision option 3, decision option 4, A, B, C, and D. Then I will move decision option 5, Excel's alternative 5. Then decision option 6, staff revise. Decision options 7 and 8. That's my motion.
Madam Chair, and I assume
Commissioner
that
Tuma.
you intended to include a small modification on 3 that staff just made.
Yes, thank you. Sorry, I
Striking the
forgot that, but that's... So on decision option 3, strike the language in 1.5.1.4 at the very end that says in docket 24-248.
You rock, you got it.
Boom. I do everything right on my birthday, apparently.
I see a whole, the president's in the background there. That I see a laundry basket. Usually we bring all our presents for our events in big laundry baskets. So I assume that your kids brought a laundry basket full of presents for you, or?
No, as some people have observed, that laundry basket has been there for a very long time. So I should get on that.
On Commissioner Sullivan's motion, is there any other discussion? And the motion's clear? Great. We'll then vote. Commissioner Tuma.
Yes.
Commissioner Means.
Yes.
Commissioner Sullivan.
Yes.
I also vote yes. The motion passes 4-0. Thank you very much, everyone. There's no other business before the commission, so we're adjourned for the day. Have a good one.
Bye, everyone.